Ready, start. The High Court was then impressed by the contents of the letter dated 21st May 2004, wherein the respondent has asked for permission to engage a private counsel. Full stop. The High Court completely glossed over the plea taken by the appellant that this document was not a part of the court-martial proceedings. Full stop. Therefore, it cannot be made the basis of grant any relief to the respondent, much less to doubt the bona fides of the official involved in the conduct of court-martial proceeding. Full stop. On the other hand, the record of court material proceedings not only reveals that the respondent and actually admitted his guilt to both the charge with the full understanding and knowing the consequence therefore, but in spite of opportunity given to him to reconsider his stand, he did not change his confession. Full stop. As a matter of fact, references to letter dated 21st May 2004 has been made for the first time only in the rejoinder affidavit filed by the respondent. Full stop. No tangible explanation is forthcoming as to what prevented the respondent from referring to this communication in the first place in the court-martial proceedings, or at least in the appeal prepared by his under section 161 of the Act of the Competent Authority. Full stop. Para. Notably, such a case was not made even in the original writ petition for reason best known to the respondent. Full stop. Obviously, taking that plea in the rejoinder affidavit for the first time was with a view to confuse the issue so as to the rescisal from the voluntary confession already given in the court-martial proceeding. Full stop. That cannot be countered, and such a belated ought to not be interested by the High Court, and that too in a casual manner, and especially when the appellant in further affidavit had mentioned the circumstances in support of the assertion that the document relies by the respondent is a forgotten document. Full stop. The respondent was called upon to produce the original, which he never did. Full stop. Neither the learned single judge nor the division bench analyzed the pleas of the appellant in this behalf and aid granted to the respondent by directing remand of the court material proceeding in spite of a finding that the said document was not part of the court material proceeding that had resulted in awarding premium to the respondent who had approached the court with unclean hands and to give opportunity to resile from the voluntary confessions made by him, and which fact was justly recorded in the court-martial proceeding by the concerned official who the integrity is the impeccable. Full stop. The High Court should not have entered the plea of the respondent that he was prejudiced to give confession in absence of disclosure of names of those officers and who had no opportunity to counter the allegation made against them. Full stop. Hence, this reason weighted with the High Court must be also fail. Full stop. The last reason weighted with the High Court is also devoid of the substance. Full stop.